defendants and third-party defendants refused to offer any um, lump sum to get my client relief from the guarantee.
What would your attorney's fees be at the present, David?
Your Honor, I haven't looked at it, but they're probably, approaching around the $50,000 mark. I will say to you, Your Honor, I feel like I'm doing the work of two attorneys. The reason I say that is because, like I said before, I have gone to the, 10th degree to try to get this thing resolved. We have located third-party lenders for the defendants and third-party defendants to apply for credit with to try to get my client released. Of those 4 third-party lenders that I identified, to my knowledge, the defendants and third-party, actually, defendants only apply to one of them.
So before you get into the details, Dave, relax for just a moment. So today, as we speak, in the claim that you have right now, and for the record, Deb, I can see my courtroom, which is kind of nice. So, your claim right now is for breach of contract, correct? And all that's associated, the bad faith, all that kind of stuff that goes along with those cases. And your damages would be $50,000 plus attorney's fees, correct?
Yeah, attorney's fees, costs, and expenses, correct, Your Honor.
In the new causes of action you are attempting to assert, there's no change in damages and no change in attorney's fees, correct? The damage claim is still the same.
I would say generally, Your Honor, I'd have to look at, we do have a proposed claim under the Fraudulent Transfer Act. I don't know. I'd have to just double check to see if that provides for any statutory damages or any other damages.
You would be bringing that, not to get into the motion yet, but your client is a shareholder, former shareholder. How is he suing on that act? What's his...
As a creditor, Your Honor.
A creditor of who?
A creditor of the company and all of the individual defendants and third-party defendants.
All right. So, other than that particular damage claim, and in terms of your breach of contract claim, these other causes of action you wanted to, like negligent misrepresentation, fraudulent transfer, fraud, misappropriation. I think there's 3 of them. I apologize. Let me just read them. 5 of them. Fraudulent transfer, intentional fraud, negligent misrepresentation, unjudged enrichment, and of course the appointment of a receiver is not relevant to what I'm talking about right now. But there's 4 of them basically then, correct?
Yes, Your Honor. And just looking through the proposed pleading, we are demanding punitive damages. So I just want to get that on the record.
Punitive are allowed in contract claims, yes or no?
I'm sorry, Your Honor, you kind of faded out there for a minute.
Apologies. Are you aware of whether punitive are allowed in contract claims?
There are rare exceptions, Your Honor, where punitive damages can be awarded in a breach of contract claim. And
of course, there's always the fact that the pleadings have to conform to the evidence.
Yes,
correct?
Your Honor.
All right.
Yes, Your Honor.
So, there's 2 motions. There's a motion to add a cross claim in a third party and that third party defendants, 2 new individuals. I think one's the wife and daughter of Mr. Zollman's client. And you seek to name them as PRPs on these other theories and also, I guess, on the other contract claims as well. Correct, Mr. Dahan?
Yes, Your Honor, but just to be clear, they are already third-party defendants in the case.
Okay, you're just seeking to add these other claims,
Correct, Your Honor.
right? Right.
Yes.
So, in the case itself, let's pretend that I had the ability to understand all of and I had in front of me 4 years worth of corporate returns, and I was able to establish that there's some portion of those funds that the corporation paid were to be were inappropriately paid as part of your claim to show the breach. And let's assume it was $100, David, and the corporation doesn't have it, but the individuals have it. And assuming for the moment that a jury determines that, you'd want the $100 back from those individuals, or do you want the corporation to pay it? How does it work?
From all defendants and third-party defendants jointly and severally, Your Honor.
So, in assuming arguendo that the line items that you mentioned in your pleadings, potential pleadings and in your certifications, assuming that there is a reasonable determination by a jury that these items are not allowable corporate expenses, and that sounds like an expert, David. They're not allowed, and as a wasted asset claim you have as a shareholder or as a creditor, you think that amount of money should form the nucleus for you being paid $100,000, or at least to have a guarantee, correct?
Correct, Your Honor.
So that if a jury determined on your contract claim that you're owed $100,000, as you wanted in the main claim, but if a jury determined it was $100,000 and you were seeking to then levy on that amount, by that I mean bank accounts, homes, all that sort of stuff, you'd be more interested in stopping any transfers or continuing spending of money in a certain amount, correct?
Yes, Your Honor. That's part. Our relief is twofold. Obviously, monetary damages, but also to stop the bleeding by having eventually a receiver appointed by the court to take control of the company.
Well, you're more interested in getting $100,000, and I don't know what I didn't say to you. I apologize. I do not know the effect of COVID-19 on this corporation's business, so you'll have to explain to me what it does. Go ahead, David. Do you know what the business does, David?
Yes, Your Honor. So they are in the business of, from what I understand, servicing elevators, installing them, maintaining them, performing routine maintenance. If a part needs to be replaced, then they'll go out there and they'll do it. So that's my understanding of the service they provide, which I would suspect is still a valuable need, even dealing with COVID-19.
So we'll do a pretend that they're in some level of business, and I don't know. I forgot to look this up, and maybe you know it, David. When's the trial on this? Is there a trial date established on this case?
Your Honor, originally there was a trial. This is very early on in the case. There was a trial date set of April 27 of this year. But what happened subsequent to that was we were in court, with Judge Belgard on more than one occasion, and I believe the court realized that this matter was, not going to be a simple collection matter, and she reassigned it to Track 2 and entered an order recognizing that deadlines would have to get bumped out, including the trial date.
Right. So as we sit here today, not getting into your emotion on discovery, as we sit here today, do you think paper discovery is completed?
No.
Have you taken any depositions?
Mr. Zollman noticed the deposition of the bank's corporate designee. That did take place. I was there. Mr. Ferguson was there as well.
And what was the result of that deposition?
Well, Your Honor, from my perspective, we confirmed that the only thing that the defendants, and when I say defendants, I really mean Stephen Mangold did, was simply ask the bank whether they would be kind enough to remove my client as a guarantor without more.
When you
and
say
the other
that,
thing
you mean Fulton Bank?
Yes, that Fulton Bank would not release my client just out of the goodness of their heart.
Yeah, they won't do that without having someone else stand in their stead, and they have reassurances that that entity has the economic wherewithal and or money is posted.
Well, either that, Your Honor, or
right now they settled with you, so that's kind of moot. So, if I go back to the beginning of this, assume it's a $1.6 million a year annual revenues. Have you ever seen any of their corporate returns to establish what the profit is that they're paying the tax on?
I have seen some of their tax returns, yes, Your Honor.
And what do they report to the IRS as the profit against which they apply the percentage?
Your Honor, I don't have those at my fingertips, but I can tell you, and this is part of our argument, really, whatever they report as a net loss or net profit is irrelevant, because what's happening here, Your Honor, is this is a textbook example of a family.
No, you don't have to tell me that. I was going to ask all that. Just bear with me. If you don't have the net profit number, and typically it's about 10%, but I'm okay with saying we need that number. As you do your calculations for the years in question, which is 2017, I think, or 2016, 2017, 2018, what can you determine, do you think, was paid that shouldn't have been paid to people involved in this case?
Well, Your Honor, my client's position is that the defendants and third-party defendants were required to offer something to Fulton Bank to have my client removed as guarantor. The settlement agreement.
That's true, and that they did not do that, and so therefore you're seeking $100,000 today.
Plus the attorney.
Correct.
Yes, generally, yes, Your Honor.
Yeah, 50 plus 50 equals 100. So that the question I'm grappling with was, why get it so complicated when it's a simple matter of having the company put aside $100,000 in an escrow fund that no one can touch?
Your Honor, here's the answer. This case was set. This is the second round of we'll call it a 2-round fight. There was a prior case that was handled by Judge Baldwin, and that was a case that was initiated by my client for minority oppression and other tort and contract claims. And in that case, and this is important to note, Your Honor, Judge Baldwin, there was an application made by my client on less than what I presented to the court in connection with these motions. There was an application to have a receiver appointed. Judge Baldwin recognized that and approved, granted the motion, appointed a receiver, essentially to take over the company. Then what happens? There's a settlement that's reached between the parties in the first lawsuit in 2015. Pursuant to that settlement agreement, Your Honor, the defendants and third-party defendants were to use best efforts to get my client released from the guarantee. That clearly involved doing more than just contacting the bank and asking them to remove him. It obviously, like Your Honor said, involved either coming up with somebody to replace Mr. Carswell as a guarantor who was financially worthy or coming up with a lump sum amount to pay the bank to entice them to release my client. They never did that. All they did was call and ask the bank, would they release my client? That's clearly not what.
Okay, David, I'm gonna, for purposes of today, can we just agree that's true, and then get to my point? What I'm trying to ask you, if your damage amount is 50,000 and your attorney's fees are now 50 with a projected attorney fee budget of another 50, that's $150,000. That's a lot less than 250 plus 100 for 350. And the question would be to if you're successful, then they have to, you're done. They pay you back the money. As of today, we sit here talking, the bank's going to give you a release. You're off, your credit's good, and you just want the money back from Mr. Zollman's client. And you want to make sure the money's there. And all these allegations all relate to the breach of the contract, no question about it. And I'm not too sure that we need more than that for purposes of getting the case ready for trial. That does not mean, let me finish, that does not mean that you're not allowed to explore every aspect of everything you've told me by way of documents, records, depositions, accountants, creating your own world of experts, etc. Because if your claim as a former owner is what you're claiming, and you're at $150,000 once you finally get out of extra attorney's fees, unless you can tell me the fraudulent transfer has some trebling or doubling thing going on. That's where we are. So by adding the extra counts, it just makes it more attorney intensive. I'd rather get the defendant to pay you the money or to put it aside. You understand what I'm saying, David?
Yes, Your Honor, but may I respond to that?
Sure.
Okay. Your Honor, we've been there, done that. For the past several months, I have pleaded with Mr. Zollman to have his client come up with money. I undertook efforts to have third-party lenders made available for them. And I was told by one third-party lender that if there's equity in his house, that he believed that there was an opportunity to get credit to Mr. Mangold. And they refused to get an appraisal done on their house and give it to this credit facility to see if there was equity. They've maintained that they don't have any equity in the house, which is false. They've refused to offer 1 penny, Your Honor, as a lump sum to get my client released. That forced my client's hand, and he's a hardworking individual. He doesn't have a business like Mr. Mangold that's supplying, that's basically funding his lifestyle. His wife's on the payroll, his daughter's on the payroll, and his son is on the payroll. They buy exotic cars. They go to Wawa. They go to Starbucks. They take out large cash withdrawals. They take out large ATM withdrawals. They're sucking the money out of this company to my client's detriment and to defraud creditors. And that's why, Your Honor, we're at the point where, in my opinion, future efforts to try to get the defendants or third-party defendants to pay my client what he is owed and what he has laid out to get released from the guarantee is going to be a waste of time, because all you're going to hear is what I've been hearing from Mr. Zollman since I entered this case, and the same thing he's been telling the court in the prior lawsuit and this court and this lawsuit, and that is, my client keeps trying. I'm sorry, he's not successful. There's nothing we can do. But here's the bottom line, Your Honor. Throughout the years of litigation in the first lawsuit, the years that have passed since the settlement was reached in 2015, here we are 2020, 5 or 6 years later, they have not provided one piece of evidence that shows who they applied to, where they applied to, when they applied, what documents were supplied to these credit facilities, what were the responses, why wasn't credit given, what else needed to be done to
So,
qualify for credit? Nothing, Your
David,
Honor.
David,
Nothing.
David, what you're telling me is you're launching again why they breached. You're telling me that that's the liability section. I'm okay with that. I told you I wasn't doubting that for the purposes of today. I told you, well, my concern is you've asked for a lot today. You've asked, I think I heard you ask for an amendment and a custodian. And all I was saying was all that's designed to make sure there's $150,000 at the end of the day. And I can order the corporation to set aside the money, put it into an interest bearing account, in lieu of a custodian, in lieu of new claims. But I just need to know if I'm right that the damage structure is a 50,000 plus 50 maximum right now, not to mention what else you want to do as time goes by. If that's the case, I don't want to spend too much time on this. Your motion to add claims, may change the focus of discovery, but I don't think so. I think you're entitled to all the paper and all the electronic data over the past 4 years from all parties. And if you haven't been provided it, I want to know why. And if Mr. Zollman he gave me a certification and they said they don't have it, then in the trial, the fact that they don't have it becomes a credibility thing when you can point out that no, they did have it and here's evidence of it. You can't, if people are going to lie on an affidavit, I'm not saying that they're lying, by the way, Mr. Zollman, please. But if they are, he's just a lawyer. Mr. Zollman's just a lawyer. He's talking to a client. The jury will assess whether they're credible or not. So, that said, assuming for the moment that I granted your motion, it doesn't change your damage structure. It may change the direction of discovery, but that's about it, David.
Well, Your Honor, I would. That's a fit. Well, that's a fair statement. I would just add one little thing to that, Your Honor. The scope of discovery really won't change with the amendment to the complaint or to the answer in third-party complaint. The facts and circumstances.
There is one thing that, David, there is one thing that changes. The allegation, and Mr. Zollman's absolutely correct here, even though you're a good writer and you can analyze well, ultimately, an expert's required to analyze the financial reports, the ins and the outs, and come up with the real numbers and a determination as to what is an appropriate charge and what isn't. And then that's your expert, and he has his expert, and then the jury makes the call. So that's why I asked you how much money we're looking at. If we're looking at putting aside $150,000, then I'll do that. Because then you can go back to your contract claim. And in that contract claim, you can raise on cross-examination all these deficiencies that you believe exist. I mean, it's evidence rule 101, the documents speak for themselves. Their answers you may not know unless you take their depth. But at least you'll be able to take their depth and find out exactly what their answers are and determine whether or not that's a basis for evidence that would allow you to seek additional damages. See what I'm saying,
Your Honor,
to you, David?
Yes, but can I respond?
Sure.
With respect to the expert, Your Honor, I would respectfully state that we don't need an expert. And the reason we don't need an expert is because a fact finder, whether it's Your Honor or a jury, can easily analyze and determine whether or not going to Wawa or Starbucks is a legitimate business expense. It's not. I don't need an expert to say that. I don't need an expert to say that Mr. Mangold should not have taken bonuses, should not have paid himself as handsomely as he did while he knew that my client was out there and he owed an obligation along with the other co-defendants and third-party defendants to use best efforts to have my client removed as guarantor.
No, but that's all. But David, this all goes to liability. Your damages are not changing. Okay, I'm going to switch gears now. It's 2:15, and I think Deb tells me I have another one. I want to talk to Mr. Zollman. Mr. Ferguson, you don't have a dog in this fight, right?
The only thing I would say, Your Honor, is if Your Honor is considering putting $150,000 into escrow with the court, my client has a first lien on that cash.
Well, that's sort of why I asked you in the beginning. What are you going to be doing with Mr. Zollman and his client, given the decreased revenues on both sides?
Yeah, and unfortunately, we haven't resolved that. So,
yeah, I know.
My client, I think, would require me to oppose any order from the court putting those funds into court or an escrow account based on.
Are you opposing the request for a custodian?
My understanding was that they were simply amending their pleadings to add that as a count.
Well, but I know Mr. Dahan from other cases. He'll be making the next application is to do that. So
I'm sure it would be. I'm sure it would be, and I think if we haven't resolved the case with Mr. Zollman's client by that point, my client would probably have me file an opposition, depending on what is asked for in the motion, of course.
So let me ask you about your case. Your case is pretty clean. In other words, here's the amount of the money that was loaned, and here's what we didn't get paid. There's a default, and here's the amount. Why didn't you do a summary judgment motion? Or if you did, what happened to it?
Well, I actually prepared a summary judgment motion, Your Honor, and then we got into discovery, and I was, I guess there were some issues that were raised by Mr. Zollman's client that I discussed with my client, and we decided that, the expense of going forward with the summary judgment motion may be outweighed by some of these issues that Mr. Zollman's client was raising. So we focused our efforts on trying to resolve the case first, holding our summary judgment motion kind of in our back pocket if necessary.
What I meant was the amount that wasn't paid on Evidence Rule 101 is clear. The amount of the payments are clear. The amount of damages you seek, whatever that says in terms of attorney's fees and the reasonableness is redeemed. So, I mean, that's what I'm talking about. Mr. Zollman may have defenses, but it's part one. So I'm going to talk to Mr. Zollman about a variety of matters. Mr. Zollman, I recognize you opposed the motion to add claims against existing parties. And I recognize that it's based on a variety of factors. Factor number one is he doesn't have an expert. Not too sure he needs one right now, though I do agree with you that ultimately I think it's an expert case, notwithstanding David's belief that it's not beyond the ken of ordinary jurors. Second, the status question intrigued me. I didn't ask David about that yet. But what I did read in his papers, he suggests that his client is a creditor, in the sense that the settlement agreement gives him creditor status. Lastly, I forget what the third basis that you indicated, but I'll let you chat a little bit, John. I jumped on everybody else first. Now it's your turn. Go.
Well, Your Honor, thank you very much. And the representations that I made in my papers are accurate from our standpoint, and I'm not going to belabor that at risk of causing Mr. Dahan to become more agitated than perhaps he already is. But, Your Honor, this is in fact a very simple collection case. This is a line of credit that was in effect for a number of years. Mr. Carswell was a former member or a former shareholder of the corporation. This line of credit was maxed out at $250,000 at the time that Mr. Carswell was bought out of his interest in the company. We did negotiate that. Mr. Carswell had counsel. We did agree as part of that agreement that we would assume responsibility for that outstanding line of credit, which again was maxed out. And we entered into an agreement in that regard to use our best efforts to try to get him off of that loan. In the interim, we maintained that loan as current. We made the payments that were required, and we also made an additional principal payment each and every month. We received an assurance, and I say this somewhat from an advocacy standpoint, but we received an assurance from Fulton Bank that as long as we continue to make payments, we were not going to have an issue with this loan being called in. By way of an example, Judge, at the time that Fulton Bank filed this suit, I think that they were claiming an amount due and owing of about $192,000, $193,000. That line of credit had been at $250 at the time we negotiated the buyout from Mr. Carswell. So what that supported was the proposition that Mr. Mangold had continued to make his payments religiously. There had been no default. There had been no issue. And this went on, Your Honor, for a number of years. And when I took the deposition of the Fulton Bank rep, they decided internally that it was time for them to call in this loan. Again, I guess that's their prerogative, but I felt that they were somewhat stopped from doing that based upon the understanding that we had, the agreement that we had. But again, we've continued to make the payments. And I would say, I said this also, which I think is significant, even after this lawsuit was filed by Fulton Bank, I instructed Mr. Mangold continue to make these payments because that's the deal that you entered into with Fulton. And he's continued to do that up until as of perhaps tomorrow, he'll be making another $2,000 payment, which is the $900 that's owing on interest and $1,000 against the principal. I think the amount is down to $190, $189 before Mr. Carswell made this $55,000 payment. Now, again, we've been in discussions, Your Honor, trying to resolve this with Fulton Bank. We wanted, more than anything else, to get Mr. Carswell out. Mr. Dahan has been very aggressive and zealous in his advocacy for his client, and we recognize that. It's driving up costs, it's driving up expenses. I know what the agreement says. It talks about indemnification. Once we were trying to get money together to get Mr. Carswell out, we haven't been able to do that. Mr. Dahan feels that we're not being forthright in trying to do that. We have a different opinion about that, and I think the evidence will be to the contrary. But nonetheless, now that Mr. Carswell has bought himself out of this, there's no question he owes him that money. That $55,000 went directly against that line of credit, and it's now down to about $140,000. I've had discussions with Fulton Bank. I don't want to go into the details, but that was kind of a condition precedent to us finalizing this with Fulton. And I am very optimistic that very shortly we're going to have an agreement with Fulton Bank, and we're going to have this issue resolved. The only issue that's going to be remaining is going to be Mr. Dahan's claim on behalf of Mr. Carswell against my client. I'm confident that we're going to be able to do this. You asked, Your Honor, about the status of my client's business. It's been impacted, no question about it. He does two things. He does maintenance of elevators, and he does modernization, which is like replacements and things like that. His business has been impacted, but he's still working. So he's still in a position to make his payments to Fulton, and I believe we can still enter into the agreement that we have discussed, that I discussed with Fulton Bank without going into those details. So we're hopeful that that's going to resolve it. Now, going back to the issue, Mr. Dahan is being, again, I think he's being zealous, and obviously I recognize and I appreciate and I can respect that. It's going over the top, Your Honor. From my position, all he's doing is making these claims against my client's wife, against my client's daughter, and he's done that for the sole purpose to force my client to settle out. All of this was done before Mr. Carswell bought himself out of the case. So he was doing that in an effort to apply pressure. And I understand that, and I respect it, and I think he even said it in some of his papers. I'm trying to up the ante a little bit, Judge. He said this to Judge Belgard. All these motions, they're intended to up the ante, to make them do something, because he doesn't feel Mr. Mangold is being forthright and being righteous in trying to get this accomplished. So, listen, it's not lost on us. We're trying to do whatever we can. But now that it's accomplished, it's funny, Judge. When we were with Judge Belgard last time in open court, I suggested to Mr. Dahan, I said, if Mr. Carswell is of the position to be able to buy himself out of this, let's do that. And at least then he's out. We'll stop the bleeding on your side, and we'll move forward. We'll accept responsibility for that. That was met with such ire and such upset. But it's funny, because that ended up what happening. Because we learned that through this process of trying to understand who had what and who had what creditworthiness, that Mr. Carswell was actually in a much better financial position than Mr. Mangold. And now he's bought himself out, so now he's out of the case. So I want to cut it off, okay? I know he's got fees. I know he's got a claim for this $55,000. I want to reach a resolution with Fulton Bank. I don't want to continue to propagate this case and make it more. We're talking about more discovery. He's making all these claims for fraudulent transfers. And again, I think it's overkill now, because I think that the purpose of it was to force Mr. Mangold to do something. He can't get blood from stone. Mr. Dahan has his arguments about what waste has happened. We disagree about that, but that's where we are, Judge. I'm just trying to get to the end game of this, but I don't know if that answers your question or if I just.
No, I appreciate that. I have a couple dumb questions by way of follow-up. So you agree with me that what I've been said a little while ago is that your damages is limited to, at one level, $55,000 now. And then the second level is some kind of an attorney fee application. Isn't that fair, Mr. Zollman?
That's fair, Your Honor.
So on the attorney fee, if I was to cut it right now, if I said the case is over, I'm not saying I'm doing this, suggesting it, the case is over, and we would have a redeem application, wouldn't we, by Mr. Dahan to say, look, this is why I did it. This is what it's worth. These are my hours. This is the rate in the area. That kind of stuff. Isn't that fair?
That is fair, Your Honor. But my argument would have to be, Your Honor, that my argument will be that Mr. Mangold, despite the allegations, has exercised reasonable efforts to procure the release of Mr. Carswell from the loan. And if he
this is possibly a good argument. It might not be a zero, by the way, redeem. It wouldn't be 50,000, but it's always somewhere in between. That's the way it works. And it's not because judges don't feel like doing it. We know that there's a lot going on here, so I'd rather settle the case. But I don't want to settle it yet because Mr. Dahan is upset, I could tell. But I want to have an opportunity to talk to you individually, John and Dave. So that said, I don't know what purpose it serves. Well, let me ask you this. The company, do they have the ability, assuming you settle with Fulton, do you have the ability to set aside some money so that Mr. Dahan feels assured? Any thoughts on that?
my initial thoughts on that on supporter are that he does not have the money to set aside at this time, Judge. But I would have to speak to him about it. He hasn't had the money to come up with a lump sum to try to get Mr. Carswell off. I don't think the current events have helped him in any respect, and I know that they probably hurt him.
So with the revenue, and that's why I asked, I didn't look at the returns, but if the revenue in the firm is, let's say, $1.6 million, which is, let's call it $100,000 a month. I'm not saying that's the right number. $100,000 a month, and how much of that can they give to David's client to make him whole over the space of a year? See, that's how I would look at this in my simple world I inhabit. And that would be something he'd have to look at what David put in his complaint about. Here's some expenses we can do without while we're waiting. You do that in your own life. I do that in my life. Everybody does. Nowadays, I must tell you, I don't know what it's going on in anyone else's, but everyone I know is talking about cutting back just to make it through the next 2 months. That said, do you have any interest in, when do you think you'll resolve this with Doug so I could talk to you, Dave?
Your Honor, Doug and I emailed, I guess, maybe yesterday about this, and he was going to speak to Fulton Bank, and I'm sure that they're limited in their ability to look at these things, but I would hope that we could have an answer shortly, but I'll have to defer to Doug on that.
I'm going to do the following. I'm going to diary this for a week, and I'm going to talk to you and Dave. You'll let me know what Doug's doing, obviously, and then I'll talk to you and David about the matter. I'm going to talk to David privately. We're on the record now. So right at this point, we have a $100,000 damage claim. At this point, we have the request to add claims, and to continue discovery. Let's talk about discovery before I talk about the claims again. What do you think is left, Mr. Bowman, paper-wise, paper and electronic?
I don't think we have a lot from our perspective, Your Honor. We took the full bank rep. I think we've gotten all the documents that we wanted. We may have done a couple follow-ups for a couple other documents that I think Doug may have produced something recent, but I think we're okay at that standpoint.
All right, David, what do you think you need paper-wise? Don't launch into your motion on contempt. Just tell me what you think you need.
Well, Your Honor, we need the responses to the outstanding discovery requests. Number one. Number two, we need to know to whom the defendants and third-party defendants have applied for credit. We need all the applications, all the correspondence, all the documents related to those applications, any denial of credit, any request for further information, Mr. Zollman has repeatedly said that they've made reasonable efforts to get financing. I've been hearing that for months.
No,
And
David, don't launch.
I know, but Your Honor, my client is so frustrated because we keep hearing the same, and it's really nonsense that they are.
No, Dave, don't do that. Don't do that. Here's what I want you to stay focused on. We'll start from the beginning. I don't know if this is true, so I'm just going to lay it out there this way. Number one, I want all paper and electronic discovery that exists as to the corporation, which would include but not be limited to returns, financial statements, and employee and officers list for the years 2016, 2017, 2018. Second, I want any paper or electronic evidence of any applications for credit applications on behalf of the elevator company, and Mr. whatever his name is, Manfold?
Mangold, Your Honor.
Mangold, excuse me. Okay, I want all that in 2 weeks if it exists. Or John, if John says, I'm sorry it doesn't exist, you got to live with that, Dave. I mean, that's a problem in all this discovery. It doesn't exist.
No, I understand that, Your Honor, but here's what troubles me, okay, from a credibility standpoint. Mr. Zollman's associate represented to, when we were there for a conference, showed Judge Richmond some correspondence claiming that supported their argument that they made reasonable efforts to get credit financing. That has never been provided to me, Your Honor. So yes, am I upset? I'm definitely upset. There's no reason why that can happen.
David, relax. I'm outlining a path here. And I forgot where I was. So the paper, Sean, are you listening?
Yes, Judge.
Okay, I want you to put the first paragraph is all paper and electronic data from the defendants, including but not limited financial data, including but not limited to tax returns redacted for personal information, financial statements, and other corporate records that would be provided to an accountant. Second,
Your Honor,
yeah.
I would indicate that they sent a subpoena to our accountant, who's been our accountant for the last 10 years. We did not oppose it because I wanted them to have a picture of the financial situation.
Okay, good.
So it's all been produced, and unfortunately, it's been produced in unredacted form. It was all just.
Oh, well, then you did more than I would have had you do. David, did you get all that financial stuff?
We did get documents, financial stuff from the accountant, Your Honor, but not from Mr. Mangold, except for a personal financial statement form that was filled out in December of 2019.
And what years did you want?
Your Honor, it should go back, just to get back on the scope of Your Honor's order, 2015 to the present, because the settlement agreement was entered into in May of 2015.
Put it, if they exist, I'll put it there. And this is going to be on our confidentiality order as well, because I don't want this on the internet. I don't want this out in some cyberspace stuff. Okay, I want all that to be provided, if we can, by April 17th. David, are you okay with that date? Because I have a reason for this.
Yes, Your Honor.
Good. Then I want depositions by May 17th. Now, who do you want to depose, David?
Well, definitely the accountant, but Your Honor, can we go back to the paper discovery? Because there is more.
Well, what are you looking for? I can't imagine what else there is.
Well, I need the tax returns and financial statements from the third-party defendants.
I'm not willing to do that yet. Because the wife is the husband. And the daughter, I mean, I'm not willing to do that yet. You're going to get the corporate stuff. What else you need?
Yeah, but Your Honor, they're parties to the settlement agreement that Mr. Zollman drafted himself. They're parties to the litigation as it stands now.
Mr. Zollman. Mr. Zollman, what's your thoughts on that data?
They shouldn't be parties to this lawsuit, Your Honor. They shouldn't be parties to the case, and that information is confidential. It has nothing to do with this matter. They didn't. They don't have any information about Fulton Bank. They didn't guarantee it. They didn't agree to it. Are they listed in the settlement agreement? They are, only because Mr. Fidel had also included them in that prior lawsuit. But they're not signatories to the agreement, and they shouldn't be obligated to produce personal financial information.
Your Honor, Your Honor, they benefited from the release of the settlement agreement. They were defendants in the prior case. They're defendants in this case, and they just need to realize that. And we'll keep it subject to a confidentiality order. But Your Honor, I need that to evaluate how my client is going to handle this case moving forward, and with respect to strategy. And they are a defendant in the case now. I don't know why that wouldn't be subject to discovery.
So, let me just make myself clear. The reason why I mentioned the individual, the man, and the elevator company is because there is the elevator company and the individual who guaranteed the loan himself. He's the one who's on the hook. I know you say the other two are, but the other two isn't proven to me to be on the hook. And you have convinced me that they are employees of the corporation. You'll get it all from them. If you do not get stuff from what we're about to give to you here, then I'm willing to reconsider that, David. Of the wife.
Your Honor, can I just make one point? Mr. Zolman is confusing, is misleading the court. The issue is not whether Kathleen Lien and Sue Ann Mangold were guarantors or were a party to the loan agreement. That's not the issue. The issue is they are clearly parties to the settlement agreement. And even if they weren't parties to the settlement agreement, that settlement agreement memorializes their understanding that they did have a duty to use best efforts to have my client removed as guarantor, and they failed in that respect. My client asserted claims against them. They are parties to this lawsuit. They're subject to discovery, and respectfully, Your Honor, we're entitled to that. I don't know how I explained to my client how he gave them a release 5 years ago, okay, with the understanding that they were going to undertake best efforts to have him released, and now we're going to say that they don't even have to produce documents to show whether they had the financial wherewithal to have him released. I mean, Your Honor, that's completely, fundamentally unfair.
I thought that we were pretty clear that Mr. Zolman just said to me a little while ago that they did not give you a client, get him off the loan. I don't understand it, David. He's told me that.
No, Your Honor. This is why what Mr. Zolman says is misleading. Okay, his clients, the third-party defendants, Kathleen Lien, the daughter of Mr. Mangold, and Sue Ann Mangold, Mr. Mangold's wife, were named defendants in the first lawsuit. They were sued by my client. That first lawsuit resulted in a settlement agreement that was drafted by Mr. Zolman himself. When he drafted it...
David. So if liability is not an issue, are you looking for damages? I don't quite get it. Just explain it to me.
Yeah, so it's twofold, Your Honor. I want to see their...
protective order, if I may. His motion for protective order is... This does not lead to discoverable information because we definitely did not take him off the loan. We couldn't do it as a matter of fact, but we did not do it. Secondly, whatever damages he has, and we stand ready to pay for it. If you're worried about their ability to pay, I don't have a problem with that. If you're worried about whether or not they could have done this a while earlier, then become the evidentiary, you believe they had an affirmative duty. The woman, the two ladies, the mother and the daughter, had an affirmative duty, notwithstanding the elevator company and notwithstanding the father and husband, to provide for alternate financing for Mr. Your client. Correct, David? They had that affirmative.
Absolutely, Your Honor. And that's what keeps getting lost here. You know, Mr. Zolman has repeatedly said the company has done this, the company has applied for that, but we need to look at the settlement agreement. And the settlement agreement clearly applies to all the co-defendants and the third-party defendants.
If they
And
did,
my client,
if they took no action, meaning individuals, then why do you need the stuff? Is what Mr. Zolman says.
because I suspect their next argument is clearly going to be, well, even if we did have a duty, we didn't have the financial wherewithal to do it. And my client has the right to explore that defense, whether it's with respect to Mr. Mangold, the company, or the other two individual third-party defendants. He should be able to prove or get discovery that we're confident will show that they had the financial wherewithal to do it, and they just didn't want to do it.
The wife and daughter, if they have tax returns, John, and if they have financials, they're to be provided under a confidentiality order for the past 3 years. And the confidentiality order will be in accordance with the suggested form that's on the internet for business cases, which is a pretty strong order. Now, David, what else are you looking for paper-wise? That's it.
Well, Your Honor, we have the responses, the outstanding responses to this for discovery. That's number one. And you covered the tax returns, financial statements for the others. I do need to know when, to the extent it's not provided in the documents or there's no documents, I do need to know when Mr. Mangold presumably or allegedly applied for financing to whom, when, all of the details. That has not been provided.
That will be, David, number one, they got to provide you electronic and paper. And if it's not in the electronic and paper, you want him to give you a statement, what phone calls he made and what door to door he did, what kind of contacts he made without having a written or electronic evidence.
Correct, Your Honor. Okay,
that's fair. What's the next thing?
Your Honor, it's not really paper discovery, but we do make an effort.
Papers only, not depositions. Who do you want to depose?
I want to depose Mr. Mangold, Mr. and Mrs. Mangold.
Right.
Kathleen Lynn.
So we'll call a party in fact depositions by May 17th. Let's make it June 1st.
Your Honor, and I understand, obviously, we're all faced with this situation we're in, but it's obviously they're all going to have to be remote depositions.
Absolutely.
I'm going to ask if Mr. Dahan wants to take their depositions, that he provide for the arrangements for that and pay for the cost of doing that remotely. I don't even know whether I'll be in the same room with them at the time these depositions.
There is I do know court reporters have that capability now.
Okay. I just want to make sure it's not more expense.
He has to pay for it. Okay. What's the next thing, David?
Well, Your Honor, obviously that'll be part of our damages, whatever expenses we have to incur to prove our claim.